We have with us Professor Prasenjit Mitra on the dais to take the proceedings forward. Over to you, sir.
Thank you very much. Thanks for coming. This session has essentially three talks. Talk number one, we have a tag team, Professor Partha Pratim Das, who will actually initially talk briefly for 5 to 7 minutes and then hand it over to Professor Prabuddha Ganguli. The first talk is on intellectual property rights challenges for networking of libraries, information, and knowledge centers. And then there will be a virtual talk on the World Digital Library, lessons learned and most likely not learned, by Professor Dr. John Van Oudenaren. And then there'll be a set of student flash presentations about their posters. But let's talk about the first talk. So our speakers are Professor Partha Pratim Das, who to this audience need no introduction. However, I'll just briefly add that I took a compiler design course from him and did pretty well. So, so thank you, sir. Along with Professor PPD, the other speaker is Professor Prabuddha Ganguli. He is the CEO Vision IPR in Mumbai, India. He's also a visiting professor at the Rajiv Gandhi School of International Intellectual Property Law, co-PI of the National Digital Library of India, Indian Institute of Technology, Kharagpur, India, and advisor at the Indian Institute of Technology, Jodhpur, India. He started as a visiting scientist at the chemistry division of the Bhabha Atomic Research Center in Mumbai in 1980 after completing his MSc and PhD, followed by postdoctoral research at the Johannes Gutenberg Universität Mainz, Germany, as an Alexander von Humboldt Foundation Fellow and as a research associate at Windsor University, Canada. He has been an entrepreneur, and there are two more pages of very accomplished accomplishments, I would think. I'll skip those for the sake of time, but I'll request Professor Partha Pratim Das to come up and introduce the joint talk. Thank you.
This is actually the presentation by the expert, Professor Prabuddha Ganguli. So I just wanted to come in to mention as to why these issues are important, critical, and how they are critical for NDLI. So basically, as we started working on the NDLI project, we soon realized that we are stuck in a kind of a protect versus provide paradox of a digital library. So on one side, on the left, are the creator, who has rights that need to be protected, and on the right are users who are looking for access, and that needs to be provided. And in the middle is National Digital Library of India, which may be working with the creator and the user directly, or in many cases, that in turn goes through a set of intermediaries on either side. So for NDLI, it's very important to understand as to what rights it will protect, what kind of accesses it will provide, given the three major components or legs of decision making, as I mark, one is a set of laws, the copyright and related laws, which is primarily focused on protecting the rights, making some exceptions for access, but primarily protecting rights. On the right are different kinds of licenses that the user can enjoy for their access. And in the middle, as we learned, are a whole lot of content where it doesn't fall into any one of them because you may not know, maybe there is no claimant and gray areas and what will eventually turn out to be right statements in the longer run. So naturally, at early stages, we were ignorant. We didn't think that we were doing something as large so as to attract infringement cases till we in May 17 we got the first infringement case from ECDL Foundation from USA. It was not our fault We had integrated Spring and Nature, and Spring and Nature did violate a clause in their terms. So we had to come across that. Even earlier, a year earlier, in May 2016, we once got a newspaper report from Bangladesh that we have the collection of Satyajit Ray's cinematographic scripts called Kheror Khata in the collection, and we were told that in Bangladesh some creative publisher has downloaded those and have printed and circulating them, selling them. So they naturally do not have any rights. We have had big collections like Digital Library of India, the Million Book Project, scanning project, which had to be shut down in May 17. It's still actually shut down because there were 169 infringement cases of copyright violation. Apparently, copyright, books that were scanned and put up were not out of copyright. So the things, the skeletons were coming out of the cupboard, and we could not have ignored this to have a serious look into the data and the rights. And that's when we kind of mobilized ourselves and had the first copyright and intellectual property workshop at IIT Kharagpur. I'm sure some of you present here had been a party to that, and Professor Prabuddha Ganguli, who is associated with our law school, spearheaded that whole learning process. And in the process, what we discovered is there's a big gap. Initially I thought, I'm from computer science, so I did not understand library, I did not understand copyright. And as I went deeper, then I understood that nobody understood what needs to be understood. So it was a great scenario to be in, and we fell back on Professor Ganguli and others to find out if we can make some kind of at least a manual for every librarian, physical, digital alike, to fall back on. And that's a manual of copyright best practices that we are looking at. So we have to look at what can we, looking at the licensing side. On the provider side, we are also doing certain experiments. That is at the ministry's level. The ministry is trying to create new national licensing model, wherein the publishers, the ministry makes agreement with the publisher, so that ministry pays the publisher directly. And if you access that content as user of NDL, then you don't have to pay anything. So it's a tricky model. It's not on par use basis. It's on an averaged volume of use access. It still is not geofenced, though it probably at some point has to be geofenced. It's World e-book Library, it's South Asia Archive are under this model, and ministry is very interested to expand on that. So these are the two different sides that NDLI is particularly interested, and there are several others that Professor Ganguli will talk about. And in this, while we were busy with all this, the third component, which is uncertain, unknown, unclaimed cases, typically covered by right statement, also, we felt it is very important for actually also consider those. So we also had a right statement workshop, which Harry mentioned a couple of while ago. So with all this, I will hand it over to Professor Ganguli. In 2017 version, he first talked about all these issues in the same platform, but today we are far better prepared, and I'm sure he will take us through the developments and possibly give us a glimpse of the manual that's getting prepared. I'll request Professor Ganguli to carry on.
Well, thank you very much. It's always a great pleasure to be in a gathering like this with so many very knowledgeable people. When I got involved in this particular project, we started looking, as PPT just mentioned, we started looking at these unknown issues on intellectual property rights. Even to us, who are so deeply entrenched in intellectual property rights, we were completely unaware of what the actual issues were at the ground level for librarians, information managers, etc., etc. So to us, we were also novices completely in this field. And so we all started together. And it all started, I was invited to give a talk in August 2017. It was something that it was a meeting of over 200 librarians. It was in Ahmedabad. And it was a pleasure really talking to everyone about copyright. And what came out of that is every librarian said we need a manual. We really don't understand. And I was frank enough to say, even we do not understand. So that's where it all started. And then when Dr. Anil Kumar, the librarian in Ahmedabad, took up the initiative to collect questions from all librarians from around the country, so that we would then work on actual problems of librarians and information managers and not on imaginative things of lawyers. So the real stakeholders, what the issues were. And then, of course, NDLI came forth and incubated this whole concept of looking at intellectual property rights in a very comprehensive manner. And that's how we got involved. And PPD has already talked about the 2 workshops that we all got involved. And as we heard, that the Hindi version of the rights statement has already been launched, and one is exploring ways to incorporate rights statements by stakeholders of NDLI to make the system more open and useful. I think we should look at the whole process as not restrictive, but how do we make it more accessible, more communicative, more useful. So the question that comes in, that when we are talking about digital libraries, I'm not going to elaborate on this, all of us know about this. The ease of reproduction, reworking, facile transmission and distribution, storage, collapsing time scales, adaptations and creations by autonomous AI, and all these. So when you come to this framework, the big challenge for all lawyers is to look at what is that facilitative framework in law that you need to promote something like this, which is the future, rather than being constrictive on that particular process. So that's point number 1. Point number 2, because we are transgressing borders, and we had some discussions earlier during the day on this, so jurisdiction becomes very important, and who is infringer, what is the liability, and a whole bunch of questions start clouding the whole framework. And similarly, you have, with all these things that happen with machine and human interfaces, who is liable, who is not, and what happens with there's a whole bunch of questions. Well, law is getting into a platform where law is not itself sure how to really handle all this. So there's more confusion than really solutions at this point in time. But then, what do? Do we raise our hands up and say nothing can be done, or we do something? That's the point. So, looking at that, very important, are 3 terms, which is ownership, rights, and responsibilities. And we need to understand who owns what. That's point number 1. If they own, what are the rights? Who owns the rights? And therefore I must know who the owner of the right is. I may know the owner, but I may not know whether that owner has the right. So there are issues of that type. So I need a due diligence of that type. And then, of course, comes in the responsibilities that come in with that. So we need to look at this. And there's a very strong interplay of these issues as we look into it. Then we go into very interesting accessibility versus affordability is a very important issue. I may give you access, but it's not affordable. Then it's not a product. You just can't use it. So a publisher or anyone comes and says, here it is, take it. But it's horrendously expensive. Then is it really access? You question something like that. And therefore, we need to look at models, business models, where we do a balancing of what is access and what's affordable. So there are a lot of case laws where we go into and look at public good, look at the interest of the owners, look at the interest of the public, and see how do you do a balancing act. Therefore, the law must look at this factor as well, including factors like right to education, right to knowledge, right to information, and a whole bunch of things that go with it. So how do you look? So you have to look at the UN Charter, you have to look at the Constitution, you have to look at all those particular factors. So you're looking at things in a more umbrella fashion than looking at it narrow from the eyes of just a mere copyright or a patent or a trademark law. So you need to look at it in that particular broad framework. Knowledge prospecting is when I use your knowledge with your permission. Knowledge piracy is when I steal without your knowledge. Interestingly, today, as I speak, a few hours back, in the Lok Sabha, I'm told there was a piracy bill, anti-piracy bill. There's a debate going on in the Lok Sabha as we speak now on this. And today, the bill, whether we agree or not is a separate issue, but the bill proposes today, as it was put in the parliament, that for anti-piracy, if you're caught on piracy, it may, apart from jail, may lead to death sentence. Now, that may be an extreme case, but that's a separate issue. But what I'm saying is as current as the last few hours as we speak. In the Lok Sabha, which is just a few kilometers away from here. So, ownership of knowledge becomes a key factor, and how do you transact this particular bit? I won't go into details of it, but very important that why copyright is relevant, because all information, library, everyone is dealing with a whole bunch of things which are either in copyright or not in copyright. The term in that particular, very important out there. Then of course, I'm not going to what is copyright, but very briefly, it's the right to reproduce a certain work, in various forms and things of that type. And there are different types of works. I won't go into details. And therefore, the question that comes in, what is violation? So one of the most common violations is, example, photocopying a book. If I photocopy a book, I'm certainly violating the copyright of that book. But then the question that comes in is, if I need something from that book for my work, can I photocopy? Can I not? Can the library photocopy it for me? Can the library not photocopy for me? Are the type of questions that were raised by the librarians, these 250 or 300 librarians in India who raise these particular questions as to what can they or what they can't. And can I scan a book? I borrow a book from the library or just take it from the shelf and I scan it. Can I? Can I use my mobile and just go on taking photographs of every page? And then, either I transmit it or I don't. So we need to answer these very, very, very tough questions that are there in these particular bits. So how do simple-minded way of talking would be, take a license, then it's all fine. Take permission and ensure that all activities fall within the ambit. Now this is very important. What is extremely important is that in every copyright law, there is a set of exceptions and limitations to copyright, which says even if there is copyright, under certain sections it says you may copy certain parts or whatever without the permission of the copyright holder, and it will not be considered to be an act of infringement. So we need to understand those sections very, very carefully, the interpretation of those particular sections as we go along, and we will come to that part. So understanding what is copyright, what is copyrightable, and what are those limitations, exceptions and limitations, so that certain acts that I perform without the consent of the copyright holder, I still am not infringing. I need to understand very clearly these particular features. So if I understand, I stay clear and I do it. So that's the framework on which we are looking at. So that's point number one. So there are exceptions, and very interestingly, if you look, now I'll confine myself to the Indian Copyright Act. Because if I start becoming global, it will be difficult because all laws are territorial. They are territorial in nature. But certain international conventions link them. But I won't go into those details at this point in time. But suffice to say that if I look at exceptions, there is something called section 52(1)(n), which says storing of a work in any electronic means by a non-commercial public library for preservation. Please mark every word, because in law, a comma, a semicolon, and every word carries a meaning. So if the library already possesses a non-digital copy, so what does it say? That if I had a non-digital copy, I can actually go and scan it or do whatever and keep an electronic copy of that for preservation. Now you have to ask yourself the question, what is the meaning of preservation? If preservation means just keeping it locked in a computer and not later on using it? Why did I preserve it? So these are the small elements in law where you hook onto certain words and then look at the implication of that and look at the periphery of that particular word and the concept. I will come to all this later, but I just want to raise how we look at it and then how do we speak to the librarians out there. I won't go to all of them, I'll just take 3 examples because it's a huge list of things. 52.1.0, and that's for library exceptions. Okay? Making not more than 3 copies of a book, including pamphlet, sheet of music, map, chart, or plan, by or, mind you, after by there is no comma, so it's by or, under the direction of a person in charge of a non-commercial public library. Very important expression called non-commercial public library. It does not say public library, it says non-commercial public library. So non-commercial for the use of whom? Of the library, if such book is not available for sale in India. Now you have to go to what is the meaning of such book not available for sale in India. So today if I go to the web and look for Amazon, and Amazon can sell me the book, can I then say it was not available in India? Question number 1. Question number 2, I go to Connaught Place in one of the corners where they sell all those old books. I find a second-hand book. Now, is that equivalent to a book available in India or what? So we need to understand those fine differences and then interpret this particular subsection from that standpoint. Very important. Now, we don't look at these with this sort of a magnification, magnifying lens, but we need to. Okay? And that's where the difference is between looking at something, perceiving it, and then interacting with it. That's what we need to do. And we need to bring in interpretations and understanding that would be facilitative and not necessarily restrictive. So that's the whole process that we're talking about. Now, so that's that part. Then there's one more library exception. And these are all the exceptions in the Indian Copyright Act. Very interesting. It says the reproduction for purposes of research or private study or with a view to publication of an unpublished literary, dramatic or musical work kept in a library, and the word museum comes for the first time in the Indian Copyright Act under this particular subsection. Nowhere else in the Indian Copyright Act is the word museum used anywhere else. So the word museum is used here. Or other institutions, so it can be archive, it can be anything out there, to which the public has access. So now the question is, what is the meaning of to which the public has access? So if you take a membership, then is it restrictive or it is public access? Does it have to be free? What is the meaning of public access? So we go into all those. So therefore, one of the questions that comes about is my library a non-commercial public library? First question. If it is a non-commercial public library, then I can take advantage of these. If I'm not, then I'm not. Interestingly, the Indian lawmakers in their wisdom have not defined in the law what is non-commercial public library. That makes this a completely open field. The question is, who is or which institution falls within the ambit of a non-commercial public library and which one does not, is the first question that we need to establish, whether IIT Delhi is a non-commercial public library or it's not. If it's not, then it can't come under these exceptions. If it is, yes. So these are various types of issues when we look at copyright law and to this. Very important part is, so there are questions that can I keep a photocopy machine in my library? Can somebody copy it? Can somebody copy it for the students and the faculty? can they take and distribute it among themselves, what can they or what they cannot do online or offline, etc. So I make a request to a librarian, please copy this for me. Now, I said, I am not copying, librarian is copying. If you have a problem, go to the librarian. Hang him or her. Can you do that? So these are questions that we need to look at. Similarly, when the library scans a book, can it convert a non-digital form to a digital form? Then you will say, there was an exception there, right? To scan for preservation. So that was for preservation. Put it in the fridge. Preserve it. Right? Don't take it out of the fridge. Freeze it forever. Is that the intention of law? So we need to look at all these particular bits in great detail. A museum preserves, an archive preserves. For what? So we need to look into all these particular aspects as we look into the law part of it. So we don't read them as literary works. We have to go into this particular thing. So that's it. So therefore, the first part that comes in is obviously there's a big gap between the non-digital world and the digital world. So what is true for the non-digital world is not necessarily true for the digital world unless said so. So therefore, we need to look at those specific aspects which says if this is in the non-digital world, to take it to the digital world, what do you do? So that's the first part. Are you allowed? Are you not allowed? Is the first question. If you're not allowed, question of digital libraries don't come about. The second part is you are allowed. Second proposition is you're allowed. Fine, preserve it, but you can't distribute it. Then what was the use of doing that particular? So how will digital libraries be born out of a situation if the law is so restrictive? You need to look at each of these fundamental aspects into it. And therefore librarians, quite rightly, are not the people to really go into this part of the law and do this dissection, out there of the law and say, can I not? They need help and assistance. So it is at that stage that we came in. And so you have all these. Similarly, professors. So far I'm talking about education institutions. Professors are giving a course. They create course packs. For this course, chapter 1 of this book, chapter 6 of that book, chapter 10 of that book, and chapter 20 of that book. Right? Now, so what will happen? One will photocopy those and make them into a course pack that becomes like a book. So have you infringed copyright? So now you have to go and see, does the law permit you to do that? Interesting. The law says in India, you can, provided it is in the course of instruction. The expression is in the course of instruction. Now question is, in the course of instruction means what? And about 3 years ago, there was, whether I agree with the judgment or not is a separate issue, but there was a very creative judgment by Justice N. Law in Delhi High Court. There was a case where all, with our Delhi School of Economics, where they created this type of course packs. They gave it to a photocopier. That fellow made all of them, and students went and bought it for a small paltry sum. So obviously, the publishers got together, ganged up, and filed a case against Delhi School of Economics and the photocopier. And to cut a long story short, under the circumstances and those facts of the case, see, this is how a lawyer speaks. Under those circumstances, the judge interpreted for the first time that in the course of instruction also meant right from the time that course pack was designed by the professor, given to the photocopier to photocopy, even though the photocopier took that from the library. Library was absolved of all liabilities, And there's the first case where he came up with this particular judgment saying, yes, under these circumstances and under such facts that you can go ahead and make this, and brought it under the exceptions of. So what I told you is, this is the way. So there is a judicial review. But should we wait every time for a case to happen and then go? Possibly not. So therefore, under these circumstances, the interlibrary loans. Now take interlibrary loan. I buy a hard copy in the library, we do interlibrary loan. Now, if I converted that for purpose of preservation and did a digital part, can I now sell the digital part? That would amount to an infringement, because that's not valid for the digital part. So how do we make it valid? So when you come to digital libraries, we need to look at these particular things with absolutely a magnifying lens. What we can and what we cannot. So very important. The other part is there are works for whose you don't know who the author is. You don't know who the owner is. What can you do with that? They're called orphan works, and rightly so, because you don't know the parentage or the ownership of that. So orphan works. So we need to address that, because libraries are full of all that. Museums have lots of orphan works. So how do you handle orphan works out there? And important part, we heard that when you're doing all this, you create the metadata, you curate, you do all sorts of things. Then the question is the metadata itself copyrightable? If that is, then how do you do the interoperability and how do you create digital platforms at all? So what I just quickly took you across, not to instill a sense of fear in you, but just to tell you what are the sort of spectrum of issues. What is the width of that? And therefore, at this stage, the question that came about is NDLI. So now NDLI stands somewhere in the middle of this huge ocean, either to sail or sink. You wanted to sail and not sink. And where does it stand? You can see here are there any copyright issues? How do we use copyright as a facilitator? This is very important for knowledge sharing. And NDLI is all about knowledge sharing. So how do you use it as a facilitator? And therefore, the first thing that came about is to provide guidelines to information managers and librarians or libraries. So the thing that we put down is explore the best options to exploit the exceptions and limitations of the Copyright Act and the Information Technology Act. Because the Information Technology Act brings in all aspects about digitization, what you can do and what you cannot do in a digitized environment. So now you've got to marry the copyright law with the information technology law in this country and look at how would it sort of work together and how do you sort of use all this to our own advantage. This is the point where we stand. And at this stage was this particular challenge that was thrown by those 200 librarians to us, saying that, look, you have come and given us a lecture on copyright, please produce some sort of a guide. Obviously it's not a legal document, but some sort of a guide that we can use, read, and sort of feel comfortable that, oh, we are generally in the right direction, but should we have a problem, we will go to a lawyer. But please bring us up to that stage where I can read, I understand reasonably, and then I take a call. Institutionally, I take a call. That is the purpose. And we then set up, we did not, and my style of working is, I never go for grants to anybody, because that's a big waste of time, going for grants, because then you have to write proposals, make 35 presentations, by that time you would have finished your work, till the grants come in. So rather than doing it that way, we said, let us be barefooted, soldiers. So we created a small team, and my team is right here. Would you stand up? Jagdish Sagar. Jagdish Sagar is interesting. He is an IS officer, used to be an IS officer, was a joint secretary at his time, and he's an expert on copyright law. So Jagdish Sagar. Then we have Vishwas from the Jindal Law School. We have Indranath Gupta from the Jindal Law School, and another colleague of mine from Rajiv Gandhi Law School. He's not here. His name is Shreya Motilal. So we got together, please. So we got together. And interestingly, NDLI came forth. PPD and Nandagopal came and said, please take NDLI as your staff, do whatever you want, we support you. Right? So we took this up about a year plus ago, and we started looking at all these particular factors one by one. And it took us about a year. Believe it or not, for the last 48 hours, this team of 4 has actually worked continuously till about an hour ago. Okay, just to make the manual, to show you the manual here. Okay, though we have been working for 1 year, but it's like every examination that, last minute, that what question is somebody going to ask? So let's prepare for that question. So it's what that same student spirit came in us, and for the last 48 hours we've been working together in that. And therefore, before I come to that, so the issue that comes about is promoting structured disclosures, development knowledge for statutory protection, global knowledge in open domain, IPR subject to certain conditions of fair use or fair dealing. A very important part, there's something called exhaustion of IPR. That means, when I buy a book for the first time, and I've already paid for the copyright and other things of that book. Now, it comes under what is known as the first sale doctrine. So when I bought it, I own it now, but I don't own the copyright. But the copyright law says that because now I own it, I can sell it to him. Copyright owner cannot come and say, take my permission to sell it to him. Copyright owner cannot come and tell me, you can't lend it, therefore I can do interlibrary loan. So interlibrary loan and all those factors come about from that particular bit, where the IPR is exhausted. So therefore you are well within the right to do things of that type. So that is where we come into. And of course very important is other laws of the land you need to look at together. So you sort of create a little khichdi of that law. And then, after making the khichdi, you separate the dal and the rice. Okay? So you do all that and work it out. And that's the way we work. Now, so these I have already pointed out to you. And so I will come to this right statement last. So this is the copyright, we have called it the copyright guide for libraries in India. Why India? Because we are at the moment addressing issues as per the Indian law. Because the law in India, the law in the UK, law in US, law in Australia, or law in Bangladesh is very different. So we need to be very, very clear in which jurisdiction are we talking about. So we're doing that. And then of course, you can see the credits we have put there. And of course, it's supported by the National Digital Library of India out there. And the disclaimer, of course, like every other lawyer puts, we put the disclaimer. But importantly, I just thought I will give you a quick tour of what this guide looks like, roughly. So this is what the copyright, and I'm not taking you through, so you can see the version 001, 9 December 2019. What we are going to do is, after this particular meeting is over, we will put this up in the NDLI website. What we would like you to do is please study it. Please comment. So we will invite comments from you, and please feel free to be as critical as possible. Please, we will give you about 2 months, right? Please send us your comments. We will probably create a mechanism, maybe a cloud mechanism or whatever, to give your comments. We will pick all the comments up, we'll revise this, and then by March, we will issue the final one. And that will be the final one that we shall issue. So that's the process we will follow out there. And so very quickly, of course, that's the same thing. And then what are the contents? So we're giving an introduction to it of copyright law and libraries and library operations. And we have picked up certain aspects of library operations as have been defined by those 300 librarians or 250 librarians. And we are trying to address those issues, and including many of the issues that have been raised by NDLI and the experience that NDLI has gone through in the last 2 years of handling situations of this type. So we want it to be a document on the ground. We don't want to fly high in the air. So we want to be realistic. So please look at this document. Please come back to us. It's my humble request to you to give your inputs as experts into it. And we value your both your judgment and your comments out there. And as you will see that we have gone through this whole process, and you can see here, including government publications, etc., which apart from other things that you handle all that, and what all can be done by the public at large using all these particular bits. So these were the questions that were raised. I'm not showing you all those questions, we have them all, but broadly suffice to say that these are the questions. And then what we have done to start with is we've given an introduction in very simple language. It's not a legal language whatsoever out there. We have said about the Indian Copyright Act, we have said what is public domain, what is the work, and then we have gone taking it through all these little parts to really introduce you very quickly to what these things mean. And then after that, as we have gone through this, then we have come to library operations. So as a librarian or as an information manager, you now will be able to identify. So first part, are you a non-commercial? We have given our interpretation, after a lot of consultation on this. So you will be, then electronic storage for preservation, what does it mean? And what could be the implications? That can you not, what can you do? Preservation of a copy through electronic means. Now we have given here templates. So for each of these, we have given some templates where if you want to take permission, or if I come to you for a photocopy, then what is it, the type of undertaking that you ought to take from me? Why you want the photocopy? And things of that type. So we go through all these. Then we have e-books, because we're talking about everything. Then again a template for record keeping of that. How do you go about digitization in libraries? And so you'll find we've made very simple paragraphs of each one out there. And for each one, as we go through, we then give you templates. So the whole idea is to make this into an operational document, right? So that you feel comfortable at the end of the day that this is what I ought to do as good practice or a desirable practice. Just the last part of it, which I do. So this is what this is all about. We will put it up in the net for you. Do have a look into it. And just, so that's a part. And so I thought, this is something which I had picked up, something like almost about 40 years ago. 2 donkeys. And I said, open learning and IP laws, can they partner? Both being donkeys. And you see what the tension is? Very interesting tension, right? And now, there it is. Time to talk it over a heap of fodder. That's what we are doing. And last but not the least, I thought I called it mind-boggling. The future of today and tomorrow of digital platforms, what are they? Reliving the heritage, because we want to do that. Addressing the present, continually learning, visualizing a transformative future. Because the future is not going to be, it's going to be a dynamic, transformative future, thereby paving paths to the perceived unseen. I call it the perceived unseen, right? While time takes its own way. Thank you very much.
So unfortunately, the next speaker is already online, and we are about 15 to 20 minutes late. So can we take the questions offline, please?
Really, I'm brushed up with the library exception in copyright environment. I need one more clarification from you. Is controlled digital lending of a book violates the Copyright Act? Example, In my library, I have 5 copies of print books entitled Copyright Act. Okay? Can I digitize one book and lend it for the 5 students for a particular day?
You want an answer?
Yeah, please.
Answer is clearly no. You can't do that because then you are, you take the 5 books which you have, you lend one book is fine, but you can't digitize it and give the digitized copy. No. Whether you give it for 1 minute or 10 minutes is the same.
But it is allowed in.
Okay, good.
Media.
Now, important part under these things is that whether you have a contract with the publisher. So there are lots of all these things where you have to talk about contracts. So now, very importantly, that even if I have an e-book, right? When I say buy an e-book, right? Please go and read the terms and conditions of that. It may not be a purchase. It must be just a license to use that particular e-book. In which case, you must read what is in the contract. See, when you buy an e-book,
It's a content access.
when you buy the e-book, I'm saying buy. When you do that and you make the payment before that, please go and read the terms and conditions. That will tell you what you can do with it or what you can't. And that is why what PPD was mentioning is that if we can have umbrella agreements with publishers, right, then we will override all that with an umbrella agreement. And that is what the challenge is before the country. And that is what we need to do. So if you take an Inflinet, some time ago, they had a consortium of institutions and they negotiated on behalf of the consortium. And then that consortium could use those journals, etc., etc. But if you downloaded, and if you did some mischief, you would get knocked out because your IP address was registered with them and they would knock you off. So all these are very strongly contractual. So we need to work that.
Thank you, Professor Ganguli.
Thank you.